That's just one of my many duties. As I indicated, I was at finance meeting tonight. My direct line is on this slide, so, and my direct email. So in the event that anyone wants to reach me, that is my direct line and my email. I will get back to you, obviously, as soon as I can. I am a public servant and I will answer those calls if you have any questions or concerns that would relate to this topic. So you can go to the next slide. And I have it set up. It'll just keep, if you want to keep going, you can fill this slide in, then the next one will be good right there. So, you have to just go back one now. So what that slide was just talking about was the Lassard case. And Lassard was a teacher, I believe, out of West Allis, in fact, here in Wisconsin. And she had some neighbors and some family who felt that her eccentricities and her behaviors warranted being picked up and detained. And at that time, as it notes here, prior to 1975, there were no Chapter 51 proceedings or procedures in place. And that poor individual, because of that, didn't get in front of a court or have any kind of hearing on being detained and brought in because of her eccentricity for at least 2 weeks. And then when there was, it was kind of a paper review, a cursory review, and then she ended up being, held, without any real due process for a month or two after that. So that's the case that really, created or, was the advent of these Chapter 51 procedures that we're going to go through, quickly, hopefully here yet tonight. So you can go to the next slide. The presentation is going to focus on, pretty much what the law requires as far as these elements. So this is the first element for a involuntary commitment, and that is that there has to be a diagnosis of a mental illness. As it notes, it's got to be a substantial disorder of thought, mood, perception, orientation, or memory. And as you can see, my memory has that pretty well committed because I've done this for quite a while. And it has to then be one of those 5, situations that grossly impairs a person's judgment, behavior, capacity to recognize reality, or meet the ordinary demands of life. Because I have done that for the last 22 years, I generally do have it committed to memory. That's the main thing that I want to focus on tonight, because it's probably the most common basis for a 51. If you go to the next 2 hits, you'll see drug dependent, and then if you do the next one, it's DD. Those 2 elements can also be a basis for a 51 proceeding. But one, drug dependency, as we know, depending on what type of drug, if it's a legal drug, those are harder to address. DD is for obviously people with developmental disability, and those are usually considered more permanent conditions. And so they wouldn't necessarily, fall under this mental health commitment, because those are generally for people who are treatable. Whereas the DD person has more of this permanent condition. And you'll see as we go through some of these slides, the difference between what would be a guardianship and protective placement. It usually applies guardianship protective placement for those individuals because of the permanent nature of their condition. But 51 allows us to bring them into the system if, for example, they were becoming very physically aggressive or dangerous to themselves or others. So again, the main focus for us, I think, especially given that we're NAMI, is that mental illness component. You can go to the next slide. So assuming you have that first element, these are going to be the next issues that we have to address. The first element is there a mental illness? And that's usually going to be testified to by medical personnel. And then the second element is one of these 5 standards of dangerousness. And I cited here 5115 and 5120 because 5115 is the provision that law enforcement is able to use for processing a detention, whereas 5120 is what's known more as the statute that deals with a 3-party petition. And we'll get to what some of those nuance differences are as we go through. But the 2 things that are here, I don't like to spend a lot of time on because I think it's pretty clear. If somebody is suicidal or otherwise trying to harm themselves in some serious way, or if somebody is in the second standard, homicidal, or trying to really physically, do serious harm to others, I think those are pretty clear elements of dangerousness that I think most of us are, we understand what those are. If you want to go to the next slide, I think they'll show the third and the fourth standards. And the third and the fourth standards are a little bit more, I don't want to say nebulous, but they're not right as common. So if you have somebody who has a substantial probability of impairment or injury to oneself or others due to impaired judgment as manifested by recent acts or omissions. So what that really talks about is if you think about somebody who is suffering from, a mental health, condition, that's what's giving them this impaired judgment at the time. And there's a substantial probability that injury could result to the person or others. Where we've typically used this provision is potentially for someone who may not be eating, or is almost in a comatose type state from their schizophrenia. You can see that they're in such a degenerative state at that moment, in this comatose type state, that they would meet that criteria. The other one, and the fourth standard, really is, again, similar, because again, it talks about an act or omission, again, due to your mental illness, that you're not meeting those basic needs: nourishment, medical care, shelter, and safety. Now, the difference between these two is that the length, if you read in number 4, says that there has to be without prompt treatment, that there'll be a substantial probability of death, serious physical injury, serious physical debilitation, or serious physical disease, and that will imminently ensue unless the person gets treatment. So compare that to the third standard, where I'll use that example I gave. Say somebody who's in a comatose state and has not been eating for a while, they may not be in imminent danger, right, of death, or serious disease. But we do know if they continue along that path that we will move hopefully more quickly in the third standard rather than waiting until you get to that serious debilitation, serious disease, or as it notes here, death. That's what the fourth standard allows. If it's really that serious, then you can move in as well. But we like to look at these, hopefully, and you're catching them sooner than you get to that fourth standard. You'd be looking at the third standard rather than waiting until it got so serious into the fourth. So you can go to the next slide. And then the most, what we consider the most nebulous standard is this fifth standard. And it basically requires 2 components. And the first component's on this slide, and that is that there has to be a finding or belief that the person is incompetent regarding medication. And that's what this standard is. It's telling you, it's right from the statutory, requirement. And basically it says that they have to be either incapable of understanding the advantages, disadvantages of the meds, or they have to be incapable of applying that understanding. So in the first case, if you're comatose, it's pretty clear, right? You're not capable of expressing an understanding, or maybe you're so psychotic at that moment, again, you can't, really apply any of this understanding to yourself. The second part, though, is there so that if the person does have that ability, but because of their illness, they're not applying it to themselves, this allows for the court to look at that as a potential issue where someone could have those medications, forced if they're not making that great application to themselves. So I kind of think of it as, imagine, most of us will look at our broken arm and say it's clearly a broken arm. We can tell the way it looks and the way it feels and everything else. But imagine, because of the mental health aspects, sometimes people, because of the mental health component, they won't see that broken arm, or they don't see it the same way. And that's where we get to that incapable of applying, their true understanding. So the second piece of the slide you can go to is really what is kind of the more nebulous piece that most, when this was being passed, found that it was pretty controversial, because you'll see those first 4 standards that we went through, really show some element of danger, right? Suicidal, homicidal, otherwise going to do some impairment to self or others. But this one talks about, based on a person's history and these recent acts or omissions, do they need treatment to prevent further disability, so that, they won't, if left untreated, not be able to meet their health and safety needs. I look at this as, again, it's almost like, again, public defenders and or some, rights advocates saw this as saying, well, this really isn't dangerousness standard. It's almost as if we're able to step in before danger. But that is exactly what it is. I mean, and the courts looked at this in the Dennis H. case, which we'll see in the next slide, and found it constitutional and said that it does have an element of the dangerousness, because if left untreated, that danger is going to occur. So I typically look at this as, to me, maybe the perfect scenario for a fifth standard would be somebody who has a documented mental health issue. They've been treated for this for the last 15, 20 years. And let's just say, for the sake of argument, every 5 years, there's this period around the holidays that they decompensate. When they do decompensate, they end up hurting themselves or their loved one, at home. What this standard really allows you to do is to step in so that on year 5, 10, 15, if we're now at year 20 and we know that that's this pattern, it's like, wait a minute, we should be able to step in. Why do we want this individual to hurt themselves? Why do we want this individual to hurt others? That's why this standard is there. As it also notes, the prior to the Dennis H. case, which is out of Milwaukee County a number of years ago, that found it constitutional. If before that, the AG's office had to review these cases to make sure that, because it was controversial, to make sure that there was some consistency in how the 72 counties were dealing with it. You can go to the next. So now we've got 2 elements, and here's our third element. You can stop right there with the treatment. So what it is you have to have a mental illness, you have to have one of those elements of dangerousness we just covered, and then you have to be treatable. And so that's when I was talking earlier about why we look at developmentally disabled people as not necessarily fitting this scenario, because as you can see, right, treatment is, as it notes, psychological, educational, social, different techniques that are designed to rehabilitate a person, improve their setting. So the idea is to rehabilitate them, as it says, and get them back into the community. Compare that to what the statutes have called habilitation, which is kind of this assistance that you just will maintain, try to function, those activities of daily living. And that's, again, where I cite chapter 54 and 55. That's the guardianship, 54, and 55 is the protective placement statute. And those are the situations when you have somebody with dementia, DD, where, no, these are not conditions. We know they're degenerative, permanent. They're not conducive to that treatment. What we're really trying to do is, again, provide them, maintain them, and try to have them get through those activities, typically in a group home, nursing home, those types of settings. You can go to the next slide. So prior to, as I said, I've been doing this for 22 years. And so prior to when I started, the law basically allowed law enforcement to make that determination of detention on an emergency detention. Now there was a change in the law to allow local authorities, our Human Services Department, to have a say in that, mainly because it says here it had to do with a budgetary item. Since this county was going to be forced to pay for various state hospitalizations, they had an ability to review the case now with law enforcement and approve that detention. You can go to the next slide. And if anybody has any questions, I don't know if what we've done in the past, I don't mind necessarily being interrupted, but because I apologize for being behind. If you want to just, I know there's like a chat screen, you can send in a question, or we can, cover those at the end.
Yeah, if you want to put it in the chat, then John, I'll let you know if something comes up.
Okay. So I want to just go through this slide relatively quickly. If you can probably punch ahead 1 or 2, so probably put the 3 definitions. Perfect. So what this is just I want to make sure you're aware that chapter 5145 is a part of 51 that deals with alcohol detoxification and commitments. Again, as we all know, many people with either mental health issues or other conditions, you may find that there's a dual diagnosis of drug or alcohol issues or other conditions. I want this to just be that people are aware that it exists, but the statute defines these 3 types of individuals: who's an alcoholic, who's an intoxicated person, and who's incapacitated by alcohol. I'm not going to read those definitions to you because, again, they're in the PowerPoint. But the main thing to focus here is that generally an intoxicated person, what you'll see here is they're usually taken to a treatment facility, whether they can, if they go voluntarily, or as it says here, you can even just take them home. In many cases, they may take them home or some other facility, right? But the idea is that that person is just, I mean, for lack of a better word, right, drunk, inebriated. And if they just have time to work through that, like assuming some of us have been through that at one point, you just need the time to sober up. So that's who that is. An incapacitated individual by alcohol, though, is really here where it says, you know, the person has extreme debilitation, and they're unconscious, right? So they've used alcohol to the extent that they probably can't, be just taken home or to a local facility to kind of sober up. It may be a little bit more serious condition. In those cases, although I note Exhibit C, I don't know that I have it attached, but there's a notice of protective custody that a law enforcement officer can do to take that person to a facility and have them go through that detox there. And then you can go to the next slide then. And so as it notes here, generally the person's going to be brought to that facility and they're usually released within 72 hours. If they're not, then a 3-party petition under 5145 can be done for alcohol. And those 4, you can hit one more, I think there's 4 elements there, are that, as it notes, you have to habitually lack control over the alcohol. The big thing is that it substantially impairs or endangers, your social economic functioning. There has to be a pattern of that conduct. It has to be, again, during the last year where there was some dangerous element. And then there has to be an extreme likelihood that this will continue. The main thing for us is that first element in letter A is really the tougher part for us from a legal perspective, because again, you have to show the person is substantially impaired or endangered in their social and or economic functioning. So sometimes you can have an alcoholic, if we go back to that, you don't have to go back to the previous slide, but if you think about what it said with respect to alcoholic, you can have individuals who are, functioning in that state that socially they can still do things. They can go to their job every morning. And so when that happens, we're left with not being able to go ahead with this commitment because of the fact that they may not truly lack that control of their economic or social functioning. You can go to the next slide. So there are really 3 ways that Chapter 51 cases come into our system, the mental health commitment. And the first I've noted here is the emergency detention. And that's the most common. Probably 90% of our cases come in where an individual is brought in by law enforcement. And as it notes here, an officer is called to a scene and he either sees things on his own that he can base on his own observation, or he may come to a call and a loved one, neighbor, whoever's there may reasonably report to that officer that, yeah, my son took, 50 Tylenol and that's why he's passed out. Here's the bottle. And this is what he told me. So, because obviously if an officer gets to a call at that point, you can't necessarily say it's based on his own observation. He's going to have to rely on what's been reasonably reported to him. But the statutes clearly allow that. What I would note is some of the changes back in 2013, where again, we talked about how HSD had to approve those detentions. It's only if the person will not voluntarily consent to treatment. So there's this concept that we want the person to take steps, get the treatment without having to be forced or pushed into what we call that Chapter 51 involuntary commitment. The second thing is that this concept of least restrictive, which is noted in the slide, is always at issue. In other words, at all times, an individual should be in the least restrictive environment consistent with their needs. And what that means is you and I may feel like, oh, our loved one needs to be in a locked setting at a state hospital because that's the only thing that's going to help. Well, if the treatment team disagrees with that and believes that being in a group home or back home with some supervision is more appropriate, we are required, based on that least restrictive concept, to put that individual into that less restrictive setting. So that's where that concept comes from. The final thing I would note is it talks about how, again, the law at that time added a purpose statement for EDs, saying that, again, it has to be least restrictive, and it has to be somebody who is unable or unwilling to really voluntarily get the help that they need. The last piece of that slide does also note that in 2017, if the person is in an emergency room or emergency department, say, for example, overdosed or needs some serious medical treatment, what this did was allow the finding that the officer can't transfer that person until they get that medical clearance from somebody at the facility. So the second way, so that again, 90% of our cases come in from law enforcement. The second way is a director's hold, and that's simply a situation where the doctor has an individual, as it notes here, only at St. Luke's, and I use some of the old phraseology because it's probably, again, I mean, can't even keep straight. It was All Saints, then it was Wheaton, and now it's Ascension, I think. But in any event, I'll use some of that old terminology because that just dates me and shows how long I've been doing it. But there's only one facility that does this in Racine County. And in fact, it's the only facility that does it not only in Racine County, but it's the only one in Kenosha County and Walworth County. So it is the only inpatient psych facility in those three counties. And what it basically says there is that imagine you or I have some depression, and we've been treated with that, and we take medication, and all of a sudden we get very depressed, and we say, yeah, I need to go to the hospital and kind of get things righted, my meds, whatever. I just want to get things adjusted. If we check ourselves into St. Luke's as the example, and then the next day we say, I want to go home and kill my wife, or I want to go home and do something bad to my family. This provision in the statute allows that doctor to say, well, John, I'm glad you came yesterday, and I'm glad you wanted to get things right, but you're not quite ready to go home, and I can't let you go home because I believe if you do, you would meet those dangerousness criteria that we've gone through. And so then that doctor can place that hold on you, and then that would start the action, just like when the officer detains you to the facility. And then the third and final way I think will be on this particular slide as well is what's called the three-party petition. And that's when loved ones, family, neighbors, it could be people in part of the treatment team, if they feel that an individual is declining and meets those elements of dangerousness, again, right? Because no matter how you come in, whether law enforcement brings you in, whether you're brought in by a director's hold or this three-party petition, you always have to prove three things: mental illness, dangerous, and treatable. Those same elements are there, no matter how we bring it in. So that's, again, where it notes three people would sign the document. We would work with that. Human Services in our office works with that family. We prepare the petition. At least one of those people have to have direct knowledge of the person and the dangerousness. And I would note, this is probably a handful of years ago, a limited appearance was created whereby if somebody didn't agree with what we were doing, they could proceed and try to file over our objection. I would say it's not highly recommended, and not necessarily to toot my own horn or pat my own back. I've been doing it for 20 years. I know what the courts are usually going to accept or not accept. And so I can tell you in the one case where we proceeded on a limited appearance, in other words, the family tried to do it, it was dismissed within about 5 minutes by the court. So again, it's there just so you're aware, but typically our department, through Human Services and our office will review these and make a determination if it's appropriate. And, again, we've been doing it for quite a while, and I think we are, we generally get these right. And case in point, if you don't believe it, you can bring your own and the court will probably dismiss it like the other one in 5 minutes. Next slide. So this is just some of the, venue and contents. I mean, it basically tells you that venue is going to be filed where the person is, either legally resides if you reside in Racine County, or if you're present. Meaning if somebody's coming through on the interstate, they have an issue, they can be detained here in our county. The petition is going to have to allege, those same elements, right? Mentally ill, dangerous, and treatable. The notice is going to have to be given to the person, their attorney, parents, and guardians if the person's a minor. And typically when there's a law enforcement detention, the officer will serve that checklist and these notice of rights and a detention order on the person. And then what happens is, once you're detained, as it notes, the right to that probable cause hearing is going to be within 72 hours. So whether law enforcement brought you to the hospital, whether you checked in voluntarily and now the doctor thinks you should stay, or whether we do a 3-party petition and have the court agree that you should be taken to a facility, that clock will start, that 72 hours will start to run. And it's generally when the person's in custody. So you can go to the next slide. So here it is. This is what I said. It's going to be 72 hours within when that person's taken into custody. And so custody is defined as when the person is under the physical control of the officer for purposes of the ED. And so what we've been looking at in times of these cases is that, you know, sometimes law enforcement says, well, I don't know, am I detaining them or not? And I tell our law enforcement in our trainings to kind of think of it as they would with an arrest. I mean, when you get called to a scene, we would certainly hope that most officers don't just show up and say, well, I'm here to arrest A, B, and C person, right? They typically ask questions, you know, investigate it, make determinations, and then at some point they make a decision to arrest. And I try to tell them that that's, I think, the best way to look at these. And the main reason is because when you think about the previous slide we had about, if you're in the ER and you're being stitched up for a serious, you know, injury you did to yourself, or being treated for an overdose, you really don't want that period of 72 hours to run, because you can imagine, how does that benefit anybody if somebody's laying in a hospital bed in a coma? What defense do they get? I mean, how do they participate in the hearing? So we look at this as you know, again, we're very pleased that the legislature a couple of years back did change that and allow for that emergency room clearance and that medical treatment. So the last piece on then, once you have that hearing within 72 hours, it's generally before the judge. As it notes, civil rules will apply. Generally, doctors by statute can appear by phone and testify as to the need for the detention and continued detention. The hearings used to be held in the lower level conference room over there at the old St. Luke's. We could do them by phone, you know, for state hospital, but due to COVID, as you can all imagine, many hearings have been by, you know, remote through the Zoom process like we're doing right now. One thing that's interesting about these cases, the last bullet point there, is that hearings are open, which sometimes is counterintuitive because everybody thinks, well, these are sensitive and they should be confidential. But typically they're open unless the person asks to have it closed. Now, there aren't many people usually in the courtroom during these proceedings, so probably not that big of an issue, but I want people to be aware that that's what the statute says, that they're open unless you ask to have them closed. The only difference is if you're a minor, then it flips that. A minor does have a closed hearing unless they request that it be open. You go to the next slide. At the probable cause hearing, there's really 3 different dispositions that an individual can go through. And the treating doctor is going to review the situation, and he's going to determine, what we have him do is fill out what we call this probable cause sheet. Oh, you can go back. And that probable cause sheet is going to have the 3 elements. Is the person mentally ill, dangerous, and treatable? And which makes sense, right? I said those elements have to be there no matter how you're brought into the system. And then if, assuming they're met, you know, then we can move on to further disposition. If they're not, it says here, first option would be case is dismissed. Makes sense. But a voluntary is the first option then, if assuming the elements exist, that the doctor may agree to and say, so say I come in and I'm you know, broke up with my girlfriend and I overdose, you know, because she meant everything to me. And, but now I get to the hospital and I say, wow, that was dumb. I mean, I know I shouldn't have done it. And so I'm showing insight into, you know, how I've been dealing with this depression and this situation. Doctor may say, hey, you understand what's going on. You don't need to be continued in this involuntary system. He'd recommend the voluntary, and then arguably the case is dismissed, as it says, you know, after 30 days. A settlement agreement is kind of a hybrid where, say I come in, I'm same situation, overdose because of my girlfriend, and now I say, well, I don't know what people are. Why are they all upset about that? I mean, people are blowing this out of proportion, you know, blah, blah. Now the doctor might have a reason to question my true sincerity in treatment. And he may offer what this hybrid is of this settlement agreement. And so it basically says, hey, we're not going to continue in this involuntary situation, but you're going to sign a one-page agreement with us that says you're going to take meds, see your doctor, do all the things you're supposed to do. If you do all that, it can be up to 90 days, could be less, but no more than 90 days. If you do that, case goes away and it's dismissed. The reason the doctors often like this as a fallback, depending on the person, is as it notes at the very end. If you fail to do those things, you can be brought back into the system. And so an affidavit of non-compliance could be filed, you'd be brought back in. And then this last option, which will be, I think, the bind over, is again on the table. So now change the fact pattern. I didn't, break up with my girlfriend. And I'll say I'm a 20-year-old, 22-year-old at college, and I have schizophrenia, and I've had my first psychotic break, at age 21 or 22. And now I'm talking to the walls, I'm bouncing off the walls. You can see how this is probably somebody who can't voluntarily agree to something. This is somebody who can't sign an agreement after, truly understanding it. And that's somebody who we use the term bound over, will be kept, in the system. And then we'll have that final hearing coming up. So that's what it says. If you're bound over, 2 additional doctors would be appointed, to examine you. And then we'd have a hearing after that probable cause. Again, probably 90% of our cases resolve in that settlement agreement or voluntary fashion. I mean, it's very few times, like maybe 10% in ballparking would end up being a case where you're going to actually be kept. The other option, again, this is just lip service here, where it could be a case where it's converted. So now let's say when you have dementia and it's a situation that really isn't as amenable to treatment, we could convert the matter to what this 5455 is. And again, it's guardianship, protective placement. So that would be the difference if we felt that, it looked like a more permanent condition. You can go to the next slide. And then of course, alcohol detox, that'd be another option. If for example, you were acting strange and it turns out it was just alcohol or some other drugs. If those elements were to clear in your system, we'd look to move to dismiss that case. Then the medication order, we've talked a little bit about medication order under that 5th standard. It's exactly the same standard. And that can be sought at any stage of these hearing proceedings as well. So if the court is presented evidence by the doctor or treatment team that this individual truly needs this medication, and again, they're not applying that to themselves or understanding it, it can be treated and enforced then against that person's will. Again, only with that court order. Okay, next slide. So now, assuming we're in one of those 10% cases and you're bound over, then we will have a hearing, 14 days of detention. That's the statute requires. You'll generally be kept at the facility that you were initially detained. You can request a jury. It's very uncommon, but you can request a jury. We typically, again, prevail in those cases where somebody truly exhibits some level of dangerousness. All I can say is, unfortunately, I think our community sees that and then this person's dangerous. They need help. They'll probably commit. It's in situations where the person may just exhibit some self-harm that you might have more, potentially in a jury. But nonetheless, you have that right. As I said earlier, you can go to the next slide. There'll be 2 doctors appointed in that final hearing procedure. You can go next. So again, there's those 2 doctors who end up doing those examinations. Those reports have to be provided to all parties 2 days before your hearing. Again, you'll generally probably be kept and detained, but you could be released if the court finds that it's appropriate. They'll probably put some conditions in there to ensure you appear again. Testimony is usually, as we said, again, by doctors by phone. We can call the doctor, officers, lay witnesses, anybody who can testify as to that dangerousness. Again, mental illness and treatability, we look to the treatment team and doctors to be the experts. It's really that dangerousness that just about any of us, I think, right, could testify to. And then the dispositions, when you're at the final hearing, are the same thing. If for some reason the elements don't exist, be dismissed. It could be a settlement agreement, but typically when we get to the final hearing, we've probably covered all those avenues, and that's why you're probably likely going to be looking at a commitment. And so what happens? You go to the next slide. If you're committed, so now you've had that probable cause hearing, and again, we didn't resolve it in the 90% settlement or voluntary, and you're one of those 10% cases that move forward to the final. If you end up being committed, as it notes here, HSD will monitor it. There's a clear prohibition against firearms now. That's been for the last 10 years. The court, as we said, depending on your level of understanding of those advantages, disadvantages of the medications, could order, meds without your consent. Next slide. I see we're coming up on 7 o'clock, so I want to just make sure that I want to be cognizant of people's time, and I apologize for being late. So let me know, Nicole or Michelle, if I need to move more quickly. But I would think I'm just about to the point where I want to go through a couple things that I think are more helpful to everybody. So initial commitment, as it notes, is generally can be 6 months. The recommitment can be up to a year. So assuming you've had that treatment for 6 months, but the treatment team feels there's still not enough insight, there's still some element of risk if they're not getting this treatment, then that extension can be requested, and the court could extend that for 1 year after year after year. Again, depends on the situation and how well the person's doing. We have some people who get off of a commitment at the initial 6 months or maybe a year and a half, and some, as you can imagine, depending on their insight and ability to treat their illness, could be on an order for 10 years. If they're not complying, as it notes, you could be picked up and brought to the hospital. Next slide. So there are going to be we're going to go through these real quickly. This is just so it's on your radar that if you're dealing with individuals who are under the age of 18, parents and guardians can generally check them in. Next slide. There's a provision in the statute that says if you are brought into the system and the doctor feels like, oh, we got it wrong, you're just suffering from alcohol or a drug, overdose, and all of a sudden after 24 hours, 40 hours, you completely clear and you don't need to be on a mental health order, the doctor can release you and basically terminate the case. The idea is, it makes sense, right? We want that if the doctor sees that that's appropriate. You can go to the next slide. Next slide. I, again, just put this out there so that people are aware. I think the liability exemption in the statute really is there for the law enforcement or social workers who are making that determination as to, do I detain or not detain? Do we, are we going to really have to take action? And so what this basically says is if you do this in good faith, you're not going to be subject to liability. So, I would say, I haven't seen this in a 3-party petition, but imagine you and I were wanting to help a family member or a friend. Again, I think as long as we act in good faith, that person's not going to likely be able to come after us and say, well, why did you file this petition? Why did you detain me for a couple of days? Now, that being said, I'd go back to the Lassard case, that first slide. I mean, if you and I were just like, we don't like our neighbor and we're going to try to, file this 3-party petition. As you can see, if it's proven that we didn't act in good faith, we won't have that liability exemption. Oop. I think we may have just lost her. Okay. Is that her battery? So I don't know if I'm going to be able to share. Oh, you can do it? All right, perfect.
Here, let me unmute.
Probably about.
Yeah, she just made me the host, so let me.
Yeah, we were probably somewhere, Michelle, around 20 some slides, I would think. If you can, probably about,
yeah.
I guesstimate is somewhere.
Let's see here.
It'll be pretty far down. Yep, there's liability. So whatever the next slide is, what are we at, 26?
Yeah.
If you got it, the next slide after this would be.
Next slide, okay.
Yep, yeah, we just talked about that one. So then again, I want to just, so people are aware, for dementia and Alzheimer's patients, sometimes depending on their behaviors, they can be detained because it looks like it's a mental health issue and their actions are dangerous. What this case basically said was, if you really only have dementia and that's the only condition, we really don't want you treated in this 51 system. I'll go back to that guardianship placement system, 54, 55. Okay. So that's the difference here. But what this case doesn't really address is whether or not there could be a dual diagnosis. And again, just like I said, sometimes with mental health, you may have alcohol or drug issues. Sometimes with mental health, you may have this condition of, well, is the person also suffering from depression as well as dementia? So there can be those dual diagnoses. In those cases, you can certainly still act. So you can go to the next slide. All right. This is just to tell you, you probably are aware there was an assessment, center, our SAIL program was opened in 2010. And it's gone through a number of machinations, as you probably all know. There was, I think, once it was at St. Luke's Hospital, once it was at HSD, and now it's been at Dominic Drive for a while. It's just a facility that we've been able to use, to try to cut down on the number of hospitalizations. Because when you didn't have this facility, right, it was like, well, geez, and it's not safe to go home and we don't have an alternative plan. Sometimes you fell back on a detention at the hospital. This really has been created, and I think it has done wonders. It's cut down on our number of detentions because instead of having to detain, having this service and this possibility for someone to go who's in crisis for a short-term stay, like it says, we can avoid those detentions. Go to the next slide. So in the last 5 minutes, I just want to kind of talk about how these cases work, just in general. So what drives these decisions? And the first thing, like I said, is this least restrictive concept. And I want to just go through the players that are involved. Our office, Corp Counsel, we are statutorily required to represent the interests of the individual and the public. And so what that really means is we're supposed to ensure that, right, the individual and the community is safe. That's what we do. We also, though, have to make these decisions under the legal framework that I just went through. So I apologize again for being late, but if you look at all of those, the framework, the statutory elements, the statutory requirements for a probable cause hearing, and then a final hearing, we have to analyze it in that framework. So we can't always just be treatment centered. So for example, I didn't, able to distinguish between probable causes and final hearings. At the probable cause, for example, that legal standard is just, is there reason to believe the person meets these criteria? But when you get to that final hearing, because now you're going to be holding the person longer than that 72-hour period. At that point, the statutory requirement for proof goes up to what we call clear and convincing. And so again, I want people to understand that we are here to ensure the safety of the individual, public, and that we have to follow these guidelines and these statutory requirements. You can go to the next slide. Oh, well, it did, you don't have to go back, but that we also rely then, because we're not the treatment team. I'm a juris doctor, a doctor of law. I'm not a mental health, specialist, MD, PhD, otherwise, right? So we rely on HSD and the treatment team to really tell us what is going on with an individual from that treatment perspective. The judge is another party involved in these cases. As you can see, they're similar to what we do. They're going to want to make sure that the public and the individual is safe. They're going to look at that legal framework, obviously, but then they also have to kind of balance those treatment needs. And so what it says is they may or may not rely on the team because they get to make that ultimate decision. Now, I will say that for the most part, judges are like me. They're a juris doctor, doctors of law. They will hopefully rely on what the treatment team is telling them. And then the last part there is in that slide, and you go to the next, is that the court determines that initial level of care. So it takes a snapshot at the time the person's before it. But that doesn't mean that tomorrow or a week from now or 2 weeks from now, that concept of least restrictive hasn't changed. Remember, the judge sees that person in that case at the moment. And if they get better a week later, maybe the judge felt that that person needed to be at that initial level of care in a hospital. But if they've improved a week later, they should probably be going to a group home or home or whatever it may be. You on the next slide. And then HSD has probably got a little bit more of the complicated situation because their department's really involved in these cases. They focus on treatment. They're going to look at the person's, diagnosis. They're going to, to determine where's the most appropriate place for this individual. They're then going to look at whether or not there's bed space available in whatever facility they're looking for. And they are, by law, the SHIELD law is another statute that is in place to basically say that funding and budget issues, whether we like it or not, right? Money does make the world go round. They have that ability to focus on what is in the budget and what funding is there so that they can't be required, for example, to create, for example, one person group homes for everybody, right? I mean, it would just, you can imagine the funding and the budgetary issues wouldn't survive. And so the other thing that HSD will look at is going to be on this slide. Next slide. Is that they generally control, though, that placement and level of care. So once the court takes a snapshot and says, this is what I see today, they're going to monitor that person the next day, the next week, the next few months or year. And they will, as it notes here, if they improve, they'll go down that ladder. If they decompensate, they're going to move up the ladder. So if they were at home doing well, but all of a sudden they decompensate and they become suicidal and they overdose or what have you, you can imagine that the system allows HSD to get involved and bring them back in to the hospital, group home, whatever they may need. Again, HSD is going to rely on us, hopefully for legal advice, and they're going to rely on the treatment team, for that person's, history and treatment. Next slide. So this is, I believe, our last slide that's just going to talk about the other parties that are involved in these cases. And the one would be the treatment facility, where the person is. And they make their decisions, again, similar to HSD, based on treatment. What does this person really need? And they're the doctors, they're the social workers. So the legal concerns and procedures are not, of a significant concern to them because they focus on the person and their treatment. They'll also look at whether there's bed space, the funding and cost considerations. And the last piece I want to just kind of hit on is this public defender, because that's another one that can sometimes be difficult for families who want to help somebody, is that the public defender will act as adversary counsel. That's what this slide's telling you. They act as what that person ultimately wants and that person's wishes. So I say compare and contrast best interest in a person's, wishes. If you're appointed as a guardian for somebody, you have to do what's in their best interest. A guardian ad litem is appointed to do what's in the person's best interest. But the adversary counsel is there to do what that person wishes. So if they say, I think this is a kangaroo court and I don't want to do any of this and I don't believe in any, this is improper, that will be the obligation of that public defender to bring that argument and that position forth for that person, as opposed to, again, what a guardian ad litem does in, if you've seen, child support, family matters with juveniles, somebody's usually appointed there to do what's in their best interest. And those two things may not always be aligned, right? What is in your best interest and what your wishes may be are not necessarily the same. So again, I apologize for being late. I think that's the end of my presentation. Certainly there's a lot of information about the elements and how this process, works if you're in a probable cause or a final hearing and commitment. And then I wanted to just give you a little bit more of what kind of drives the decisions with the various players that are involved in the court system if an individual is in what we call this involuntary commitment process. And again, realize that I think all the players involved want these to be voluntary. We only want to be in this 51 system if we feel that the only real help and necessary treatment for the person is on an involuntary basis. So I'll take any questions. I don't know if there's anything in the chat or if anybody wants to raise their hand or whatever.
Hi, and thank you for this information.
Yeah, thank you, John.
Sure.
Oh, my question is, in my line of work, I hear the term thrown around, he was chaptered, she was chaptered. And so is chapter 51 point something, that's what that is? Or are there lots of chapters that can get people committed to a facility?
Yeah, it really is chapter 51 to answer that question. When people use that term, that is what it is, that it's the chapter 51 commitment. Now, as I noted in the PowerPoint, and in fact, is this going to be on our website so you guys can?
Oh, yeah, you bet. We're recording this tonight.
Yeah, so
So we'll put the link up.
if you remember, there were a few elements where I said 5115 and 5120. Those are the most common, that when you hear people say they've been chaptered, that's what they're going to be referring to.
Okay.
There's that 5145 alcohol commitment. And I would also note, as I noted about guardianship and placement, there is a provision in chapter 55 for protective placement where you could be taken into custody, as well. So imagine, maybe it is an elderly person who is not, they've got spoiled groceries. When they do put something on the stove, they leave it on and it's created a fire in the apartment complex. Those individuals can be taken into custody as well, and will be proceeding under that guardianship and placement theory. But that is arguably, a chapter as well, chapter 55. But for the most part, I think what you're referring to and what you're going to hear, throughout the community is really referring to that 5115 or 5120, and probably mostly 5115, because as I said, 90% of our cases are through law enforcement. So that's probably what they're referring to. Go ahead. Yep. Any other questions, concerns?
Hey, John, can you hear me?
I can.
First of all, fellow Whitewater grad, and I'm glad you joked about. I'm glad you joked about the alcohol part, because I spent many nights at the pumping station.
Yeah, there you go.
So our problem is, I have a son that's, and maybe you don't want to. If you don't want to get into specific examples, just tell me.
If you don't mind, I'm going to undo my tie a little bit. So that
Yep, I'm with you.
It's been a long.
Yeah, so we have a son that's been diagnosed bipolar.
Mhm.
He's been taken into hospitals. He was 51. We're in Oak Creek in Milwaukee County. He's actually on county hold for a year and a half. We've had him to many hospitals.
Correct you there. I mean, I just want to, if you look at what's in the PowerPoint, the difference there is that he's not necessarily been on a hold. I would suspect if he's been on orders for a year and a half, he was probably brought in on a probable cause hearing, went to a final,
Yes.
was probably committed, and
He
then
was.
on a commitment order for probably the last year and a half. So
Well, yeah, actually it's over, but yeah, correct.
fair enough.
Yeah, he actually threatened me. So, the
Yep.
police got involved and they brought him in, and I'll say we won the hearing. So he was on a 3-day hold and let out right away.
Yep.
He has no awareness of his illness. He's bipolar 1. And plus at that time, there was some schizophrenia going on.
Mhm.
But he's been taken to hospitals in the nicest areas of this country because he's endangered himself.
Mhm.
5 separate times. We've rescued him, quote unquote, taken him, got him from Alaska 3 times. He's fallen into rivers. International Falls was the last time. Most of the hospital stays obviously are because he's been endangering himself.
Mhm.
We've had no problems with the insurance companies. We've had no problems with the doctors. Obviously they can't talk to us, but we can talk to them, right? I mobilize.
Yep.
They know everything.
That's one thing we didn't talk about, but that confidentiality is a significant issue when you're
Right.
somebody who's an adult, correct?
Absolutely, they will take it because the doctors want to help you.
Yep. Yep.
And they read it and they know they have background. But our problem is in between the police and the doctors is I'll say the ACLU, the social workers, the crisis units. Everybody has the right to be homeless, and we've heard that many times.
Mhm.
When I look at your criteria, and I've looked at it many times, I'm an accountant, so I like things, blocked, and
Yeah, linear, yeah.
yep, exactly. I cannot see why this kid is not helped.
Mhm.
And right now, we're playing hard glove where we're not rescuing him. He was in Fairbanks, July. He called for help. Well, only if you pre-register for Rogers Memorial up here in Milwaukee. The sheriffs up there were so helpful. He made it all the way back from Fairbanks to Seattle to Detroit and never got on the plane in Detroit. He had no ID. He lost everything up in Alaska. I got him, a replacement ID, scanned it, sent it to the sheriff. So that's what he used, his a paper driver's license to get back to Detroit. Somehow now he's back up in Fairbanks. And we only know that because he's 25 and on my wife's insurance. And we can see he had, they brought him in for observation October 19th and 20th. He has no money. I don't know how he got back up there. How do we help this kid? He has nothing. The high for the next 10 days is going to be 1 degree. He's been up in Barefoot, Alaska, population 10, and had no money. This is going back a year. We've had him to every hospital. We bribed him to go to Mayo. We've had all the tests, ruling out everything else. We had the metabolism done, the DNA, what medications work best for him, brought it back to Milwaukee County. They gave him no medication.
I guess.
How do we help him?
Yeah, I wish I had, some great answer or the magic pill, or whatever it is. I mean, my wife is by profession a psychologist. And so, I think that's, I just don't have great answers for you other than to say that, as we all know, there isn't a cure, right, for schizophrenia. There isn't going to be that, necessarily even magic pill to always treat it. Everybody's going to be different. And I think what complicates your situation is, the chapter 51 that I just reviewed is the Wisconsin statute. So arguably it covers all 72 counties. But as we all know, each county can be different, right? We just elections, so people vote one way or this way, right? And there's different population, different size. And you said there's only 10 people in, Barefoot, Alaska. So the point is that even though the Wisconsin statutes cover Wisconsin's 72 counties, you can, I hate to say it, but I'm part of the Wisconsin Association for County Corporation Councils, and you can get different interpretations even on our very own law.
Well, I can tell you the difference between you and Milwaukee. I can sense you're open-minded. Milwaukee County, we talked about the three-party petition, third-party petition, whatever. Don't even start it. You'll never get it is the answer we got.
Yeah. And again,
It's the same here though, too.
What's that?
I would say it's the same here for third-party petition. We tried to put my brother in on a third-party petition. He has severe PTSD. He was a heroin addict. He had threatened to kill himself multiple times. He'd broken into my mother's house. He had threatened me with weapons, and nobody wanted to hear it.
Yeah. Sorry.
All I can say is that, and again, one, I will say this. I think Milwaukee and our county are different. I, like you, I live in Milwaukee County. I live in Franklin. So I know that they're different, and obviously just population and the number and the volume that they get. I don't necessarily compare, but I would agree that they're generally different.
I think
I can say that we do have the process. I can't speak to theirs, but we do have a process where if that paperwork is filled out by Human Services, my team, there's a couple of other attorneys who now, as I'm getting more and more gray, I see in this video, I had a couple of younger attorneys who do these in our office as well. I can just say we do them. Do we do them as often? Not necessarily, because typically what we'll see is if an individual has had contact with law enforcement, or they've been at a hospital and they went in and out. Typically, remember what I said, the same elements have to be presented, whether I do the petition or law enforcement or a doctor. And if those aren't met, and when a family tells me, yeah, well, we had them with the police and then we did this, I can, and again, I'm not gonna speak for every county, but I do the CIT training for our law enforcement here. They typically know this process because they've been through the very similar PowerPoint that I just did with you.
Okay.
And yeah, I can say typically what happens in those cases is they probably didn't meet the criteria of
Well,
danger.
how do we
You know,
change the
maybe-
threshold of danger?
It's tough. I mean, you saw the 5 standards. I mean, I can say that,
But you can like you said, every county is different. You can interpret those different. I would
Correct.
say potentially falling in a river in International Falls in February when it's 17 degrees, I would say that's a definite danger to himself.
I would tend to agree if you can, again, tie that to his mental health state. You know,
Well, exactly. Well, there's many of those. The other thing, I don't want to tie you up, but
yeah,
since you live in Milwaukee County, we're Oak Creek, you're Franklin.
yeah,
The other thing I found really frustrating, there was a pickup order, which is a county thing, right?
generally.
Yes.
Yep.
Well,
I mean,
where's
it could be statewide too, depending on the language, but go.
yeah, this was a county pickup order.
Mhm.
Where's the county sheriff going to find a kid that's walking? He's not going to walk on the freeway. He's walking on city streets, and there's no communication to the individual municipalities. I had to get a call, a 3-way call going, sheriff, Oak Creek Police, and me to get paperwork to Oak Creek so they would pick him up.
Yeah.
That's ridiculous.
Yeah, I can only say that that's probably not uncommon either. You're talking about just jurisdictions, same with the different counties. I mean, I think that's
Right, but in today's day and age, I look at what can I change, and I'm at least, you have hair, I got a couple more years too, and then I have more time to work on this, and it's probably too late for Lyle.
Yeah,
But there's some things that should be so simple to fix.
yeah,
Communication is simple today. Look at us,
yeah, yeah. I don't disagree. And I guess I would just say that it's just difficult in the sense that, because I don't want to say I feel your pain and say I'm, Bill Clinton, because I don't have the son, or the loved one, that's going through this. I've had friends, that I know. But it is frustrating. And I think that's why I want to have people look at this PowerPoint or the outline or whatever you want to call it, so you can get a sense of what those standards are, right? And then realize that, like you said, they are entitled to a public defender. So I'm not going to bring in ACLU or what people's politics are, but right, they get by law, a public defender is appointed, and they're going to, depending on the situation, right, they're going to, if they have to represent that person's best interest, what you and I think are best for the person is not going to be what he and his attorney are thinking. And I mean, I can even tell you just recently, our judges rotate every 2 years. And we have a judge who, I mean, I don't want to espouse to his politics if he's ACLU or not, but I can tell you that in the few months that he's rotated in August, he has allowed a number of our recommitments to just be dismissed, because he has kind of this freedom, idea, right? I mean, you see it, right? I don't want to wear a mask, or I do want to wear a mask, right? I mean, so you see some of this, and like you say, so I can tell you that I can just say in the 20 judges that I've seen, over the last 20 some years, they're all different, and they take a different approach, where some are very guarded ad litem, want to do what's the best for the person, get them to treatment. And some, like this current one right now that we have, I think is going to be taking that position of, well, the person has as you say, a right to be homeless, or a right to do these things.
Yeah.
So, and that's why it's so critical that they fit one of those standards of dangerousness.
Right.
And then that we can connect the two, the health issue with that. So
I don't want to take up your time, but
even when we do, a judge, like I told you in the slide presentation, a judge gets to make the call. And so if he disagrees with us.
Yeah. I don't want to monopolize your time,
black
but imagine the conversations we could have at Mitchell's or pumping station.
Exactly. Exactly. Yeah, but it's difficult. And that's why I don't have a magic pill. All I can do is say that people like you who have loved ones, who go to bat for them and who are doing all they can for them, you're the system. You're the help that they're going to have.
Yeah.
And I can tell you, unfortunately, I would say probably over the 22 years I've been doing these cases, it's rare to see a parent, a sister there. And I can tell you, when they are there, those cases are generally positioned for much better success.
Interesting. Thank you.
You bet.
Yeah, thank you for the question.
Mhm. I know I'm looking at the only chat looks like was about the battery dying.
And
So I don't know
the
if
first
there's any
number
other-
there, the first number there is what Kurt mentioned,
I'm
Here
not
to
a
help
Boy Scout. I was
program.
not prepared.
Yeah.
So,
All
well,
right.
this has been great. Thank you, John, for
Yeah.
Yeah, this
taking
was
the time to
awesome.
talk.
And
with
if you
us.
have
It's great.
questions about anything that I sent or questions about process or how things work, call my office if I'm not able to answer it. I like to think I've been doing it for a while, so I probably can, but there's other people in our office too, and, review the cases and, hopefully provide, some insight, because it is, like I say, it's our public service, it's our public duty. We're paid by you guys as the taxpayer, and that's why I make myself available.
John, can I just ask one question before we wrap this up?
Sure.
If someone's interested, because I think third-party chaptering is the most common question we get at NAMI.
Yep.
If someone's interested in pursuing a three-party petition, where do they go first?
The best position, it would be through their Human Services Department yet. And I may have had on one of those slides, maybe under that SAIL program,
Okay,
might be, I think that's 6-8, there's a number, I think, in the presentation. If not, it's on their website,
Okay.
that's the best process. Whether we like it or not, when I started, we had paralegals who could, again, there was more funding and budget, and you had specific people designated for this work. Now, that's been gone for the last 20 years. And so we have kind of set up the system to go through Human Services. And, again, we give them the same training like you've seen and what we would give to the law
Yep.
enforcement, so that we hope that they're pretty well versed, in the process. So, if they get one where you tell me that, yeah, my brother's, acting strange, but we review it and we don't see where, if he's not suicidal and he's not homicidal, we can't fit it into one of those criteria. They'll hopefully filter those for us. But I can tell you this, if it's a closed case or any of that, we would want, and the system is set up where HSD will then contact us so that our office gets involved in that review as well. So, but it should generally start at Human Services, because they'll have the general information they can give, kind of like what we did in the PowerPoint. They'll be able to assess that initially, and work with you, so that when the few attorneys that we do have that can get involved, some of that filtering's happen.
awesome. Thank you.
Yep. And again, you can always reach out to me too. Like I say, my number's there.
Thank you for offering.
For being a few minutes late, because we probably would have been an hour or so, but
Oh,
now
no problem. No problem.
about
at all.
7:30. Were you
No
guys
problem.
very entertaining while I was gone?
You know,
Kurt
We
was
thought about it, but
entertaining.
yeah,
Good.
Kurt
Well, as
really,
long
and
as somebody took the reins for
we,
it, because
I think it
That-
just was a great organic exchange of information and resources
Yeah.
that are going to be helpful to people. So it really worked out just fine.
because that finance meeting was pretty painful,
And,
So-
Gosh.
but I got through it.
and Mike, just so you know, my wife and I have had a very similar experience to what you have described. Our son is now 30, and yeah, so we may
My
talk.
son is just
Okay.
turned 18, so I hope and pray that I, am blessed and I don't have the situations that you guys are, encountering, but I can tell you, they're gonna be lucky to have people like you, in their corner. And,
Yes.
and that's just say, keep up the fight, keep it up as best you can. And, Mike, when you have, the issues of Milwaukee or Racine County and then different states, it just so further complicates the situation. All I can say is don't give up and keep on it, because hopefully one of those treatment situations will take hold, and hopefully you can get them back. But
Well,
I know,
yeah.
got a good friend whose wife, he ended up being divorced because of his, inability to really get through that. And I can tell you, when she's gotten treatment, she's good, but it's not uncommon. I mean, as we all see, you go through this cycle, right? And again, it is what it is, right? That's why we've developed what we call that recommitment standard, so that we can stop that revolving door. I mean, there's Court of Appeals talks about it. We don't want the revolving door. We treat them, we get them better, and then they get home and they go back to their life and they think, well, I don't need the meds. It makes me tired and I'm doing great. And then
Yep,
it just starts again.
that's so common.
Yep. I mean, and I don't think the Court of Appeals talks about it because it's made up. I mean, unfortunately, it's part of the nature of the illness.
Yep.
So, all right.
Yeah.
Good night, everybody.
Thank you, everybody.
Thank you,
Thank you.
everybody.
Good luck, everybody.
Good luck.
Thank you.
Take care.
Bye-bye.
Bye.
Bye-bye.
Bye.